Hi there, I'm Jim Zirin. Welcome back to Conversations in the Digital Age. Our show is about the subject of the hour, the crisis in confidence between the community and the police department. Here in New York, the crisis arises out of the death of a 43-year-old Staten Island man, Eric Garner, who was resisting arrest and was subdued by police officers and subsequently and quite tragically died. Our guest is an expert in police conduct. He is a lawyer. He has a long history of being involved in law enforcement matters. He's Michael Armstrong. Michael Armstrong was a former U.S. attorney, a former district attorney of Queens County. He is the author of a terrific book entitled They Wish They Were Honest. About what? Of course, about police corruption. And he is the chairman of the Mayor's Commission on Police Corruption, to which he was appointed by both Mayors Bloomberg and de Blasio. Mike, we're delighted to have you here with us.
Nice to be here, Jim.
Now, the Garner case in Staten Island seems to focus on whether or not he was subjected to a chokehold, which compressed his windpipe. Now, is there a distinction between a chokehold and a headlock, and does it appear to you to be a chokehold?
This is one thing I certainly can't pretend to be an expert on, but as I understand it, a chokehold involves something where the arm is held parallel to the throat so as to put a choke on it, and it is permissible to, as long as you have your arm crooked, and so that the crook in your arm comes at the Adam's apple to bring someone down that way. But these distinctions are not recognized in a lot of places, including incidentally in the police. Because when people make complaints, you'll say there's 280 complaints last year of chokeholds. That's the only way you can check on a multiple choice checklist anything to do with having to do with the head. So,
well, the medical examiner here ruled Garner's death a homicide and said there was a compression of the neck and chest, with contributing factors being his acute and chronic bronchial asthma and hypertensive cardiovascular disease. Now, does it make a difference that here was a very vulnerable defendant who was taken into custody? I mean, physically vulnerable.
It certainly would make a difference in the charges that could be brought against him because of requirements in the various statutes, including the ones involving negligence.
Against the officer?
Against the officer, because he has to have their degrees of willfulness, intent, and knowledge that are built into those statutes that someone seeing this event on TV wouldn't be aware of. And so, you know, that there are problems when you're a prosecutor and you're faced with the job of bringing a charge against somebody who has done something that, when anyone looks at it, it seems to be a terrible thing.
Well, of course, the police officer denies that it was a chokehold. He said there was no pressure on the windpipe, and he said he simply used procedures he'd been trained to use in the police academy.
Well, both of those things could be true, and or only one of them, and that's really up to the prosecutor in the first instance, and then if he chooses to use a grand jury as a sounding board, the grand jurors.
So here we have a terrible tragedy. Someone died, and really in the custody of the police who are supposed to protect life. And it's compounded, let's talk honestly, it's compounded by the fact that you have a white police officer and you have a black defendant. Same situation that you had in Ferguson, Missouri. Now, is it a different situation as far as a prosecutor looking at it as to whether it's a black victim and a white police officer?
It certainly shouldn't be, and the question of whether it is or not is the thing that fuels the controversy that now exists. The charge is made that the minority community is at odds with the police, and that the police are treating black defendants differently than others. That certainly is different in different communities. In the New York City Police Department, where a majority of the police department, as I understand it, is made up of minority members.
Majority minority.
Yeah, that it may or may not be true. I think that the perception of what a community thinks, I've always been a little suspect of that perception being expressed by protesters and people who have an interest in being and advocating something, but I have an even greater suspicion of the perception of someone like you and me who are not in the community, and it's difficult. Certainly there is anger in the community against the cops. How widespread it is, and whether it extends to the kinds of things that some of the protesters want, like limiting jurisdiction, I don't know.
Well, the President of the United States said that the Garner case speaks to the larger issues of trust between police and civilians, and I guess he was thinking of Ferguson as well. The Attorney General, Eric Holder, was more specific. He said we must heal the breakdown in trust that we have seen between law enforcement and minority communities. Do you think there's been a breakdown in trust apart from these two cases?
I'm certainly not equipped to say. I think that indications in New York are that people are doing the best they can. I mean, you have 2 of the 5 district attorneys are African American. You have cases brought against police officers for all kinds of criminal behavior all the time. And I think that Commissioner Kelly was very conscious during his tenure of the problems of the attitudes in the minority community, and Commissioner Bratton certainly is very aware of it. So, does a problem exist? Sure, a problem exists. How extensive is it? I certainly don't know, but I think the people who are in charge of things are certainly aware of the problem and doing the best they can.
Have you ever seen a case where a white police officer was indicted for killing a black in custody or about to be in custody?
I have seen such a case because I was district attorney and brought the case back in
Queens.
In Queens County. I was district attorney for a period of something less than a year, and during that period of time, well, just before I took office, a black child by the name of Glover was shot in the back by a police officer, and there was a lot of furor and a lot of protest on both by cops and by the community about what was going on, and I authorized, on the basis of an investigation conducted by our people, including very, very competent people. John Keenan, you know, who is now a judge and was the top homicide prosecutor in the country, and Joan Carey, who later became administrative judge, and Dick Condon, who later became police commissioner, were all involved in the team. And we concluded that contrary to the police officer's statement, the victim did not have a gun, and as a result, getting shot in the back constituted murder. We indicted him for murder. Now, later on, he was acquitted, which says a lot about a jury believed him when he said that the kid had a gun and passed it to his stepfather, who ran away with it.
Now, when you indicted the cop in that instance, you believed that you could prove guilt to a jury at trial beyond a reasonable doubt. Now, suppose the prosecutor doesn't think he has enough evidence to prove guilt beyond a reasonable doubt. Is it responsible for the prosecutor to ask the grand jury to indict?
I think it's a violation of ethics, and I think, I mean, that is now pressed by critics of what's going on, who say that because you can get an indictment by only showing probable cause, why don't you just go in and show probable cause and then later on leave it to a trial? That's unethical if the prosecutor doesn't honestly believe that he can prove the case beyond a reasonable doubt. And people who press for that, it's always been amusing to me to see that see sides change when a cop gets indicted. I mean, all the right-wing conservative law and order guys suddenly discover the Bill of Rights, and all the liberals who never saw a defendant they didn't love to death all of a sudden say, bring the guy in and hang him high and forget about how to do it. And I think a lot of that's going on. For instance, this suggestion that they say you can indict a ham sandwich. And
that's what Judge Wackler said of a grand jury.
Right.
The prosecutor can indict a ham sandwich if he wants to.
And traditionally that has been a criticism by reform-minded people that you shouldn't do that. But now the reformers say, or the liberal side says, you can indict a ham sandwich, so let's do it. And I don't think that's proper. I think what you've got to do is, the fundamental thing is that the prosecutor himself has to be convinced himself that he has proof beyond a reasonable doubt and that the guy's guilty. And if he doesn't do that, he should never put it in the grand jury at all.
Well, let's talk for a moment about the grand jury system. The grand jury is referred to in the Fifth Amendment of the Constitution, and certainly in every federal case, criminal case that's brought, there's a right to an indictment by grand jury. Last year, I think there were 11 cases where in the federal system where grand juries failed to indict out of 162,000 cases. So there is the implication here that's made by the critics of the criminal justice system that why do we see two white prosecutors in Ferguson and in Staten Island failing to get an indictment when it's so easy to get an indictment?
Well, as I said, I don't know what was in the mind of either one of them, although I guess in Ferguson you could tell because he said so. I assume that they felt that they did not have the proof that was necessary to prove the cases. And again, for laymen to look at what's going on and to say, oh, bring a case, that's easy. If you put yourself in the position of the prosecutor, it becomes much more difficult. And I know that Mr. Donovan, who was the district attorney in Staten Island, has a terrific reputation as being straight as a string. And if he didn't bring the indictment, I assume he didn't think so. Now, he could be wrong. But we put him in a position where we trust him to make those decisions. And he put it in a grand jury, presumably, to get a sounding and see what the grand jury had to say. And the grand jury did not vote a true bill.
There was a report out there that the district attorney in Staten Island failed to instruct the jury on the lesser included crime of reckless endangerment. If that was so, would you fault him for that?
I don't know, but even the requirement of reckless endangerment under the statute, as I understand it, has elements of willfulness and knowledge in it that make it difficult to get a conviction. Even if you're, but reckless endangerment, no, reckless endangerment is like spitting on the sidewalk. The more serious crimes that might have been put in, like manslaughter, lower level manslaughter, or negligent homicide, they require a degree of negligence that springs from a knowledge that what you are doing is potentially lethal. And the question is that when the police officer grabbed him and threw him down to the ground, threw Garner down to the ground, did he know that what he was doing was potentially lethal? And to prove that beyond a reasonable doubt is not the easiest thing in the world.
Well, suppose this had been just a street fight, two guys wrestling, one and the other to the ground after being in a bar all night, and it resulted in a death. Would it have been an easier case to seek an indictment against the person who would cause the death than if it's a police officer?
I think so, because the police officer has a right and indeed a duty to use physical force when a decision has been made to arrest someone. In my own judgment, where the Garner situation seems to be most criticizable is in the decision to arrest in the first place. If the guy's just passing out cigarettes, why not give him a summons and tell him to show up? Now, maybe there's a reason for that. Maybe he's evaded 30 summonses already, or maybe there can be reasons. But
I mean, his crime was possession of untaxed cigarettes and with intent to sell.
Right, and whether he should have been arrested or not is one issue. But the question of once a cop says you're under arrest,
that's not a suggestion.
That has to be enforced, or else society breaks down. I mean, if I'm free to say, a cop says, you're under arrest, and I say, no, I'm not coming. Oh, okay. And then the cop walks off. You can't have that.
Now, the Staten Island grand jury heard testimony over a 4-month period, heard from 22 witnesses. We don't know whether the police officer testified. We know in Ferguson he did testify. Is it unusual for a defendant to testify before a grand jury?
Yes, it's unusual, but it certainly is done a lot of times. The reason why you, in a federal grand jury, for instance, you've got to go in there all by yourself. You don't have your lawyer, and you're generating things that, if you do go to trial, can be used against you in cross-examination. There are all kinds of reasons not to go in, but it is done for a variety of reasons. Both the prosecutors, and both to satisfy a prosecutor's need and the defense counsel's need. But it can't be done, obviously, unless the defendant wants to do it.
Now, a grand jury is a secret proceeding. What is the reason? It all sounds so mysterious, a secret proceeding. And it's like Star Chamber, from which the grand jury system came. Why is it a secret proceeding?
For two reasons. If the grand jury decides not to indict, presumably it is not really fair to have a knowledge of the ins and outs of what's going on in the investigation spread out. And also, as far as witnesses are concerned, witnesses certainly be much less likely to go into a grand jury, and they can, take the fifth and refuse if they want to, if the proceedings are not secret. Now, again, I think it varies from jurisdiction to jurisdiction. In the federal system, they have a very Rule 6 says pretty clearly that, except under very exceptional circumstances, that it's going to be secret. Now, there have been suggestions made that in certain cases it should be waived, and there are pretty good reasons sometimes just to follow those suggestions.
Now, in Ferguson, all of the grand jury minutes, apparently, and all of the exhibits were released to the public. In Staten Island, there was a selective disclosure. The DA apparently only asked for certain things to be disclosed, and the judge ordered them disclosed. So we don't know the whole story of what unfolded in Staten Island in the 4 months and with the 22 witnesses that Donovan called before the grand jury. So is it really possible fairly to assess whether the decision of the grand jury not to indict was correct or not correct?
Well, I think people make decisions about things that happen in the law all the time without knowing, more than 10% of the facts. So people can have opinions, but certainly, in my judgment, first for people to take strong opinions about what happens in a grand jury, it's usually not fair.
Now, one of the criticisms of what happened, at least in New York, is that it's said that prosecutors work with the police all the time. They depend on the police to bring them cases, to make cases, to testify. And so therefore, they're going to be very light on the police if police are under an investigation or under suspicion, because there's an institutional bias in their favor. Do you think there's anything to that?
Yes. I think, and it's something that has to be dealt with. I think and I think prosecutors are well aware of that. When I was counsel to the Knapp Commission, and we made, that looked into police corruption, back 100 years ago. I mean, back in 1972.
Well, that wasn't quite 100 years ago.
For most people, it might as well have been. But and we came to the conclusion that in the area of corruption, that we recommended that there be a special prosecutor and a permanent special prosecutor for looking into corruption in the criminal justice area, not just cops. We didn't want to single out the cops, like judges and clerks and defense counsel, anybody. But it was felt that, yes, that is an element. And the element, if a DA is working with cops all the time, certainly as a perception in the community, it can be perceived that he is going to be unconsciously biased in favor of a cop who's brought up. And that was an element. We felt that circumstances at that time were such that it required in the corruption area a special prosecutor. People strongly disagreed with us, and for very good reasons. I mean, right now, I saw District Attorney Vance on TV the other day point out that the District Attorney's Office handles all kinds of cases against cops and brings indictments against cops all over the place. And just because there's one or two highly publicized events that come to the public's mind, it doesn't mean that they are less likely to handle cases against police officers than they have in the past.
But nevertheless, Governor Cuomo has said he wants to consider appointing a special prosecutor in this type of case. And Attorney General Schneiderman, State Attorney General, has gotten into the act, and he says he should be authorized to prosecute this type of case, particularly if the defendant is unarmed and it's a transaction with a police officer in the line of duty. Now, do you agree with his proposal?
Well, to draw a distinction on unarmed is a little awkward because, for instance, in the case where we brought an indictment in Queens against the officer in the Glover case, the issue was he unarmed? I mean, we indicted him because we thought he was unarmed, but his defense was that he had a gun and he threw it away to his stepfather, who then disposed of it somewhere. And so the issue was he unarmed? I don't know how you'd handle a case like that. And I think often you would have situations where what does armed mean? If you have a knife and you're 20 feet away, does that qualify for being unarmed? Because unless you're expert at throwing the knife, you're not really a threat.
Or suppose he doesn't exhibit the knife.
Right, or you got a gun in your back pocket that you never take out. I mean, you raise your hand and say, I give up, and the cops shoot you right between the eyes.
So you'd suggest that Schneiderman's proposal isn't well thought through?
No, I think because his proposal, as I understand it, that phase of it relates to after-the-fact investigations into circumstances. And it can be argued that when you get an unarmed person who's shot by a police officer, that's a particularly sensitive situation, particularly if it involves race. If you've got a white police officer and a black unarmed defendant, that exacerbates attitudes in the community in a particularly strong way. And an after-the-fact investigation might be warranted. But in any of these things, if you're talking about the jurisdiction in the first place, to go after the case in the first place, you have the inevitable tension between the cops who really know what's going on, and who, because that's what they do all the time, and and against the possibility that they might have a bias in going after one of their own.
So unfortunately, we have to wrap up because this has been just marvelous. So how quickly time flies when you're having a good time. But I have a question for you, Michael Armstrong. Is there a new crisis of confidence between the New York City Police Department and the community?
I don't know. There certainly is something that has to be considered. As I said before, I'm not willing to take the vocal members of the minority community at their full word to say that there is. But on the other hand, I certainly can't say. And I do know that there always has been a tension between the community that is policed and the police who are in charge of it. And
always a tension between the police and the policed.
Absolutely.
So,
absolutely.
Mike Armstrong, thank you so much for coming by. And thank you for coming by. Tune in next week for more conversations in the digital age. Please visit our website, www.digitalage.org. I am Jim Zirin. All the best.